shall be heard. May God save the United States of America. The floor of the commission on this is
Mr. Rosenfeld?
Yes, Your Honor.
Step up to the podium, please.
Okay. May it please the court.
Let me go through my scenario as I understand what brings us here today, and then you can comment, respond to, or correct anything that I might have wrong. As I understand it, back in November of last year, mediation questionnaires were sent out with an order that the parties file them. The response was due on November 26th. No response was filed by you. So on December 16th, we issued an order to show cause. You then filed a response which raised a number of issues, but ended by saying counsel will timely comply with all future orders, and based on that, no sanctions were imposed on the first order to show cause. Subsequent to that, you missed a deadline for scheduling the mediation. On April 6th, we then sent out an order to show cause, requesting you within 10 days to show cause why you shouldn't be personally sanctioned for your failure to set the mediation. We received no response to that order, which led us to filing another order on May 25th requiring you to personally appear today to explain why, or show cause why sanctions shouldn't be imposed for your failure to comply with both the order to set mediation and the order to give us a response to our order to show cause. Anything inaccurate about that chronology, sir?
I think that sounds exactly correct.
So what do you have to say for yourself?
Well, Your Honor, first of all, I wanted to apologize. It certainly wasn't my intention to cause a problem with the court. I have filed, well, let me back up. I've been acting basically on behalf of my client who's been unable to pay for my services, and I understand that that doesn't matter as to my obligations to the Fifth and the Court of Appeals and so forth. But you know, I guess what happened was there's a, you know, I went through a series of different jobs as stated, you know, in my first response. And what had happened was I started with the new job with a law firm in downtown Orlando, was there for about 8 weeks. It didn't work out, so I had mail that was coming and going to one address and mail that was coming and going to my old address where I had a solo practice set up. That doesn't excuse me from following what the court says. I understand that. However, we tried to resolve this matter, which is simply a divorce, a very, very simple divorce case, just bringing you back to what went on in circuit court, myself and opposing counsel, and we were determined to, I know he filed an appeal, but I even told him, hey, do you realize an appeal is going to take longer than simply trying the case over, you know, from the beginning? And I wasn't involved with the trying of the case, you know, with the circuit court. I was only retained after some exceptions to the general magistrate were filed with the lower court. I took a very small retainer and got, you know, did my...
Mr. Rosenfeld,
yes, Your Honor.
Let me see if we can focus you back on the issue that is of concern to us.
Yes, sir.
The issue that's of concern to us is, in response to our first order to show cause, you said, sorry, I won't do it again, let's move forward. We accepted that. You didn't follow through, and that's where we're here. The merits of the underlying appeal, the history of your law practice, all of that to me is irrelevant. I want to know why, in light of the initial order to show cause, our agreement not to sanction you because of some of these same reasons, you then, in the very same case, fumble the ball.
Well, Your Honor, I don't believe in making excuses. It is what it is. I will say that I had conversations with Mario, opposing counsel, and I did see that the, you know, he had responded to the order requesting, that we set the mediation, and he indicated that truthfully, we couldn't find a mediator for our clients at the time because they couldn't come out of pocket to pay a mediator. And we were being assigned a private mediator that was wanting to charge $250 an hour. My client had...
What does that have to do then with your ultimate failure to not even respond to our order issued to you in April to explain yourself?
Your Honor, I thought...
Today's a little late to be explaining. That's one of the problems. You probably wouldn't have been dragged in here if you had responded to an earlier order and we'd had a chance to decide whether there were any
I
merits.
completely agree. I thought that when Mario, I'm just telling you, what was going through my head, that's all I can do. I thought that when Mario responded, indicated that, we weren't able to schedule a mediation due to those reasons, and I thought that, I don't recall exactly, but I understood that we were going to be able to have some time to work it out between us, and it wasn't, I don't have a good excuse, Your Honor. There is no such thing as a good excuse. All I can tell you is I have been trying to, this is the worst thing I've ever done in terms of being an attorney, and I stand here humbly before you saying that, there's no excuse for it. I get it. You gave me a break, and I had things happen to me and went through some things, but they happen to everybody, and I'm not, I'm just,
Have any prior disciplinary history with the
No, Your Honor, but, we had best intentions to try to work this out, to try to save our client's money. My client owes me money. She's asked me to withdraw. I filed a motion to withdraw today at the appellate level and at the circuit level. Actually, I filed this a couple days ago, but my client's already hired another attorney, Brent Rainey in Winter Park. And I've been back and forth with him, and but I'm not a big fan of making excuses. I'm just telling you what happened. It's my fault. I'm charged with being a big boy and following with what the court requires. Will it put me in the world of hurt if I'm sanctioned or whatever? Yes, I'm just trying to keep the lights on right now with my practice. But I've written off the time that my client owes me, if you will, to the tune of, about $1,000, and just told her that I'd get out, and sorry that we couldn't get her matter resolved. But, that doesn't mean that I've cleared it up with you all, and I apologize for that. And
there's no doubt you got all the orders from us, right?
No, I think
you got the April 6th order, which told you to respond.
Oh yeah. I got it. I got it from my PO box, and but it's when I've been between two jobs. That's not an excuse. I can just tell you that it's been a hectic. It's been a hectic 2011 trying to make ends meet, and with a job that didn't pan out, and but it is what it is. Again, I'm sorry for having to drag you all in here, quite frankly, to deal with this nonsense.
Are you back at your sole practice now? Is that your current address?
Yes, sir. And I'm trying to get caught up with clients that I was. Yes, that's what I'm doing. And I try to save people money where I can, and that's what was going on in this case. And but that doesn't excuse my not following the court's order. I naively thought that with Mario indicating to you all that the clients couldn't afford the mediator, that perhaps that would save me the time of having to do that while I was trying to handle a new job, and that wasn't the case. So I'm very sorry, and I'm willing to accept, whatever you all decide is what needs to be done. Again,
What do you think we ought to do?
Well, I don't know what, I certainly wouldn't hold it against the client. She's just trying, she feels like she's been a victim in all of this and been going through this very bad situation with her ex-husband for 4 to 5 years now. She's been trying to get divorced.
Well, I don't think we're looking at doing anything vis-à-vis the
Well,
client. It's not her responsibility.
Right, I know. You know,
I
so
think
that's
we're
why I'm
looking
just,
at
you know, I
what would
just,
be appropriate vis-à-vis you.
I mean, you know, if you all thought that, I mean, I've done quite a bit of pro bono work already in this case and in other cases, just by virtue of being a solo practitioner and working at a reduced rate. You know, I think that I'm a pretty good guy when it comes to helping people out and not ripping them silly with regard to my fees. I think I'm a pretty good attorney, notwithstanding the fact, you know, that I've not responded in the proper, you know, manner here. I mean, I really do, you know, strive to save people money and treat everyone with respect. And so I don't know if that helps you with regard to your, you know, what you should do. I mean, I don't know if you're looking for money. I don't got any money. I don't have much. I could probably, you know, pay on some sort of an installment plan, maybe. But you know, I'm in, you know, in a real bad spot with the economy and just doing the best I can. So I don't know. I don't know what you all typically do. I certainly hope that, yeah, I've never been in any trouble before. I've never had anything sustained against me in the form of any grievance or, you know, I don't know what to tell you guys. I mean, I'm doing the best I can to get caught up on some files that I need to get caught up on, and I've got a lot of work to do. But you know, you know, whatever you all want done, you know, I'll do it. I mean, I've driven over here and.
Anything else? We're going to recess and deliberate. We'd like you to just wait here while we do that.
Do you want me to step out?
No, you can stay right
Okay.
here.
All rise.
All right.
Court is now in recess. rise. Court of Appeal for the 5th District is now in session. Please be seated.
Mr. Rosenfeld, I've been designated by the court to conclude this matter with you. Suffice it to say, I think that we find your conduct to fall below the standards that we expect for attorneys that are members of the Florida Bar and the attorneys who practice here in the 5th District Court of Appeal. So if you have other cases pending before us, I would strongly suggest that you comply with the court orders, because this conduct is cumulative in our memories, and any future failures on your part would have significant ramifications.
That's right.
We take into account the fact that you have come here today and that you've had some issues in your practice. Nonetheless, I think it would diminish the dignity of a court order if we just sent you on your way without some sort of sanction. So in lieu of requiring you to pay a fine because you've indicated that that would create some hardship, what sort of pro bono work are you doing through the bar now? And by pro bono work, I don't mean clients who don't pay you. I mean cases where you go into it with the knowledge that you're not going to get paid because you're doing this as part of your pro bono work to the community. Do you do any of that through any of the local bar associations?
Your Honor, I don't, but only because I find myself doing so much. I mean, the answer to your question is no. But I do quite a bit of, pro bono work. I mean, just
so there's a difference between not getting paid, which is an experience we all had when we were in private practice, and knowing that you're doing this for free going into it.
Well, if I might interject something, Your Honor. A client called me night before last, and I do solely domestic work because I'm very passionate about small children. I've got a 6-year-old daughter. I'm divorced, and it's really dear to me. And he was about to lose his mind, and said that he couldn't pay his bill, and he thought he should call the cops. And I said, look, don't worry. I mean, I don't know if this suffices or not, but I said, look, don't worry about the bill. I'm not going to charge you for the next 4 hours of time till we get past this next situation. And I'm charging him about, $175 an hour. And I told him, and I was, I told him I wasn't going to bill him for,
Okay,
4
well,
hours of time.
that doesn't qualify.
Okay, I just
as
thought,
notable as that is, as that doesn't qualify. Where is your practice located?
in Longwood, Florida, Your Honor.
That's Seminole County.
Yes, Your Honor.
I want you to contact the Seminole Bar Association or the legal services provider over there and arrange to take on one domestic case on a pro bono basis through their pro bono program.
That'd be my pleasure.
And then I want you to do that within the next month. And I want you to write a letter. You can direct it to my attention and tell me what case you've taken on and what you've done. You don't have to give me the long story. Just say I've agreed to take on Mrs. Jones and her divorce case through this, Seminole County Legal Aid or whatever it is, and I'll see this thing through.
Yes, Your Honor.
And then we'll call it square. And I want that to be done within the next month.
Okay,
I mean, the case doesn't have to be concluded in a month, but you need to undertake moving forward within that period of time.
I can do that right away. And actually, that didn't occur to me, but that's a good idea, I think. If I might ask, I have with me an original motion to withdraw, and I'm not quite, I don't do appellate law.
Take it over to the clerk's office, and they'll see that it gets handled in the ordinary course of business.
Okay, because as I indicated, just looking back at this case, it will make more sense to simply retry it. I mean, we can see.
I want to hear about it.
Okay.
Right. All right, sir.
Thank
Thank
you.
you very much.
I appreciate it.